So say, for example, we've been able to obviously persuade our clients to go through arbitration, we've got an award, and that is binding. Do you then have to convert that into a court order, or does the arbitration award stand as, in a way, like an order that if there is a breach, you've got something to enforce?
Most arbitrations that I've done have led to court orders. It is possible to get to the determination and decide not to. One that I did where the decision, the issue was the school the child should go to. They never made an application. They had a CAFCAS report from the year before. They signed forms to say that there are no safeguarding issues had been arisen since then. I made the decision and they didn't go to court. They just implemented it by putting the child in the school that I decided the child would go to. But as I say, most apply. And the process is quite straightforward. Again, if you haven't already made an application, then you make an application, C100, I believe. You make the application and you attach to it the arbitration form. You attach to it the determination, the draft order that you want, and you attach to it the determination that you've reached from the arbitrator, with a note to the court saying, we'd like you to convert this into an order, please. If there are high profile family, or for whatever reason the parties want it to be confidential, then you would submit it in an envelope marked confidential for judges' eyes only. And it's very straightforward, and there is real appetite from the senior judges in the family courts for this to be a smooth process. So certainly if you get as far as the determination, the sealing of the order is fairly straightforward.
And how would you say arbitration could fit within other processes? So mediation, for example, how could that work alongside mediation?
Well, there are, I forget the name of the organisation, but there is an organisation which offers med-arb. So you enter into an agreement to mediate, and if that doesn't work, then, or if it would work, but if it didn't reach agreement over all issues, then you could seamlessly segue into arbitration. It isn't a service I offer, although I'm a mediator and an arbitrator, I don't do both. But I don't see any reason at all why you can't combine both. In other words, you start off with mediation, or in fact arbitration. So an arbitrator might say, I've decided the issues that you brought to me, but I think it would be useful if the parties went to mediation to decide perhaps how they would communicate going forward and how they might actually put into effect this order. So an arbitrator, I'm sure, can signpost into mediation. And you can, if you attempted mediation and didn't resolve the issues, no reason at all why the next port of call wouldn't be arbitration. And then you would go back to the process I started. You'd agree your arbitrator, you'd sign the forms, you'd lodge it, and the process will then be case managed to a determination.
Thank you. So in terms of court proceedings then, for private law children matters, often depending on the issues, if anything else doesn't crop up, it could be 12 months, 18 months, sometimes taking longer. What is the average timescale that you've seen an arbitration case take in respect of a full-blown application, not to deal with a discrete issue, an application for a child arrangement order?
So what would delay you would be perhaps the Section 7 report, the report of an independent social worker or similar. Because you would choose your arbitrator knowing their dates. So I cannot believe that the arbitrator's dates would be the thing that would cause the delay. I'm just trying to think, I did an arbitration a couple of weeks ago, and I'm just trying to think when that application was made. Four and a half months. So 4.5 months from the decision to arbitrate and asking me to be the arbitrator. That what we then did in that case was case managed with a hearing which was by Zoom, so people didn't have to travel in. Directions which included the instruction of an independent social worker the independent social workers report, 2 days of evidence, and the determination, all in that period of time. You cannot match that in court. If you make an application for a Section 8 order, often you don't even get your first hearing dispute resolution appointment for 8 or 9 weeks. You don't even get to that point where the magistrates will then case manage you going forward. But the other thing is that the process in arbitration allows the parents to say whatever they need to say. There is no question of, put it all in 6 pages with font size 12 and, kind of shoehorning people in. If they've got to this process, this point, and they feel they've got something to say, they ought to be allowed to say it. And all of that was done in the period of time that I'm talking about.
And in a case such as that, would you recommend that they would have issued a C100 and done the safeguarding before sending their order into the court for approval?
Yes. So in that case, so if you went back to when they'd made the application, that application was made and they agreed, they went as far as the Fahadra, and at that hearing agreed to use arbitration. So the Schedule 2 letter was there, the safeguarding letter had been prepared. And so when they came into arbitration with me, the safeguarding questionnaire had been filled in for the arbitration. The schedule, the safeguarding letter was there from CAFCASS, and so I was able to case manage it to the determination of the time that I've said.
Brilliant. And, I suppose not everyone will be represented by solicitors. Would you say arbitration is suitable where one side is a litigant in person or even both? Absolutely,
absolutely. So there's no reason at all why they can't do it themselves in the way that litigants in person will be before the courts. Absolutely, the process is the same as it would be there. In fact, it might be fairer and easier for them because it would go at the pace of the slowest person, if you like, in the room. So if somebody needed it to take place in a certain pace or speed, then it can be accommodated. Because the collaborative nature of arbitration means that the process is agreed between the parties. So they agree the issues and the arbitrator doesn't stray outside of that. You decide the issues the parties bring to you. They decide the venue, they decide the pace. If somebody needs special measures and they ask for it, you don't have to go through whether they're particularly vulnerable or not. If the parties agree that they will have special measures, you can implement them. It really is a great service for clients because it's not one size fits all, which is what you often get in court. It is tailored for the particular family that the parties who are in front of you.
That's wonderful to know. So if we then think about, you've got a case that you're doing and you've got the issues that they want you to resolve, but during that process, further issues come up. Can they, what do they do? Is there a separate application that they have to make to let you know that they also want you to arbitrate on X, Y, Z and the other? Or do they just put it before you or ask for directions before you again?
That's a really interesting question. And no, they have to agree it. So sometimes it's really frustrating because I sit as a recorder, as you said. So when I sit as a recorder, if I can think of a solution that isn't on the statement of issues, that isn't what their parties have thought about, I can go ahead and tell them why I think it's a good idea and give them reasons for it. But you can't do that with arbitration. So for example, I had a case where the parties were, the application was framed around a school choice for the child, but actually the shared care arrangements they'd come to when they separated would change. So by going to one school or another, it was too far away from one home. There was a middle ground solution where the parent who wanted to move wouldn't go quite as far because they had a partner who lived in a different town, which was easier for the left behind parent to get to. That was a really obvious solution, something that we could have explored. The information about the school was there. But the person who didn't want that said, no, sorry, that is not an issue we brought to you in arbitration. And so it wasn't, they'd agreed the scope and it fell outside of the scope. Interestingly, some of my colleagues said you could have gone there, but I interpret the rules very strictly, and I didn't think I could. And the person who was resisting it was telling me very persuasively why I couldn't. So yes, you have to go back to the drawing board. The parties would have to agree, in my view, what the scope is, or that they are prepared to open up that scope, and then you can deal with it. So again, it's reassuring to clients, I think, because you can say to them, there will be no hidden spikes unless we agree it. What we're taking is the arbitration are these issues which we have agreed will be resolved by the arbitration.
And just so parties are aware, is it possible for arbitrators to make cost awards in the same way that courts can?
Yes, the rules are there. If you think somebody's, in all the ways that you can make cost orders against people, you can. I haven't had to make a cost order. One of the, as I said, it's a collaborative process. So the parties come in having decided either that how the arbitrator will be paid. So either that they'll share them equally, or that one person will pay for the arbitration. But yes, there is scope for that to happen. Yeah, there is definitely scope. But I would like to think that most people who enter arbitration will behave well. But the rules are there, and you can apply.
So when we talked about the way in which, your view is that parties should be made to arbitrate. So at the present time, when you make an application to the court, you have to confirm that you have attended mediation and that you've tried to resolve matters that way. Would you say that perhaps the court really ought to consider changing the form to also include arbitration as a way so that you have that option? It's either you've been to arbitration or you've been to mediation, because it's so easy for people to go to mediation but not go into it fully, despite the advice we're giving them as lawyers that you should go with an open mind to try and resolve things just because they want to get the certificates to be able to go to court. But how do you think that the family law world should be looking at changing our forms to make it more stricter on alternative methods of dispute resolution?
So I'm not a fan of changing forms for the sake of it, because you fall into the trap that you've just described, where people know that it becomes almost a tick box. I'll put my bum on the seat and I'll make a few noises and I'll come out, and the agenda was always to secure the form signed by mediators saying, this is not compatible. I think that the family court kind of can't have it both ways. If there is this impetus that if there is an understanding that there are credible alternative ways to resolve disputes outside of the court arena, and we are being persuaded to consider them fully and properly, then it seems to me that the task is not so much about changing forms, but the family court receiving parties with that in mind. We need to know, it's a bit like you wouldn't dream of going to court without a position statement, and you know what that position statement needs to say. I think that the family court needs to change the agenda at that first hearing. And one of the questions that they ask is, what efforts have you made to not be here? And I think that if the profession understood that that was going to be a real consideration, perhaps greater efforts will be made, because those people who participate in surveys who say, I didn't even know it existed, well, that'll be flushed out at that first hearing, won't it? Because you will have to tell them, because someone's going to look at you and say, why are you here? And I'm not sure that we need to be panicked about cases not going to court. First of all, whether people, if they're your client, whether they arbitrate or litigate, you will get paid. There is also this idea that some have to hold on to clients. You don't, because actually a client who is well served is more likely to recommend you and say, I had a divorce. It was actually as amicable as it could be. It was really peaceful. We resolved it in 4 months. The children knew exactly where they stood. We could then draw our breaths, close the chapter, move on, do the second bit of our lives. I'm not sure that in the medium to long term, it doesn't do well if you're that sort of practitioner, that people know that you will use all of the tools you have to ensure that only those who absolutely need to go to court, safeguarding, mental health, addiction, those sorts of issues that you need the court's intervention because of the nature of the case, they go to court. The rest of them don't go to court. I think it helps all. You can see how if only that if the process that in court was with the right cases, it's self-evident that the pressures on the courts will reduce. And if they reduce, then those who need to be there will pass through that system much quicker. You know, I mean, it's a no-brainer. It doesn't make any sense to me why anybody would resist using an obviously worthwhile and efficient service.
Well, no more questions from me.
I was waiting for Vanessa to see if she had any more questions, but that was absolutely, you know, incredible and so informative, because this is the thing. Educating yourself allows you to have the right tools to be able to better serve your clients, and that's why we wanted to do this. But before we go, just to ask you, what would be sort of top 3 tips that you would give to family practitioners right now in respect of arbitration? What should we be thinking? What should we be doing so that we can better serve our clients?
Well, if you don't know, get to know. There are a lot of arbitrators out there. I speak on behalf of 4PB because that's where I practice. But if, for example, you're thinking about it and you're not sure, then you can always pick up the phone to our clerks, and indeed clerks of any set of chambers, but I'm focusing on us, our clerks, and ask them. We are more than happy to have a conversation with you, whether you and the solicitor on the other side, or the litigant and person on the other side. We'll do a Zoom call with you and explain our process on how we might be able to help you resolve the issues that you have. There will be no costs because the arbitrator is not engaged. More than happy to do that. So it's about, if you don't know, then get to know by asking or reading, and the IFLA website is very good and very informative. I think that there is a real sense of satisfaction if you know all the options, so that you are confident when you choose it, that that is the best way to help this particular client to resolve their dispute. There is a real satisfaction, I think, doing that. So yeah, I mean, that was what I'd say. I'd say inform yourself and make sure that you're in a position at that very first appointment, whatever the client is saying, because some will come in and say, we're going to court. And one of the things you need to be saying to them is, what do you imagine happens in court? Who is going to decide your dispute? You know, and you know, and you can only do that if you have that information to share with them. So I think, are they 2 or 3 tips? I don't know. I've given you the tips that I have.
Thank you so much for your time. We're really grateful on behalf of Resolution and everyone in the DI committee. We're grateful that you've given your time to us today. And hopefully this will be a starting point to enable our members to be armed with the right tools to consider arbitration as an option for their clients moving forward. So thank you so much. And thank you to my co-panelist, Vanessa, as well, for being here to do this as well together. Thank you so much.
Very much. My pleasure, my absolute pleasure. Thank you for asking me.